Well, the game is far from being over. However, if the court follows its rationale developed in Achmea, it should also declare the CETA mechanism not compatible with EU law. My feeling is based on the court reasoning in Achmea. The court first recalled the now sacrosanct principle of the autonomy of the EU legal order in line with a well-established case law, Opinion 191, Opinion 1009, and last but not the least, Opinion 213, where the court concluded on the non-compatibility of the EU accession to the European Convention on Human Rights. It also recalls that in order to ensure that the specific characteristic and the autonomy of the EU legal order are preserved, the treaties have established a judicial system intended to ensure consistency and uniformity in the interpretation of EU law. In the ECJ conception, the place of the national courts are indeed crucial. The court duly mentions both Article 19 of the Treaty on the European Union and Article 267, which, and I quote the court, by setting up a dialogue between one court and another, specifically between the Court of Justice and the courts and tribunals of the member state, as the object of securing uniform interpretation of EU law, thereby serving to ensure its consistency, its full effect, and its autonomy, as well as, ultimately, the particular nature of the law established by the treaties. This is recital 37 of the Achmea ruling. Unlike its Advocate General, the court did not consider that the arbitral tribunal could be regarded as a court or tribunal of a member state within the meaning of Article 267 TFEU. Moreover, unlike arbitration proceedings, the court observes that there is no possibility for national judges to review the arbitral tribunal, the arbitral award on the ground of EU law. Well, that means that concluding those BATs, member states agree to remove from the jurisdiction of their own court a complaint brought by the investors. The same can be said when it comes to the ISDS provision within the CETA agreement. It is true that the CETA negotiators were fully conscious of this risk and tried to prevent the court position in the accession of the ECHR ruling. Article 8.32 paragraph 2 of the CETA therefore states that, and I quote, the tribunal, the arbitral tribunal, shall follow the prevailing interpretation given to the domestic law by the court or authorities of that party, and any meaning given to domestic law by the tribunal shall not be binding upon the court or the authorities of that party. However, it is far from certain that this provision of the CETA will be sufficient to satisfy the ECJ in light of its case law. One possibility to provide a better EU compatibility with ISDS would be the existence of an obligation to exhaust local remedies for the investor before bringing the complaint before the International Investment Tribunal. However, the very core objective of those treaties, their ratio legis, is precisely to avoid national court, and I strongly doubt about the willingness of the EU and its trading partners to negotiate such mechanism. If rationality, at least my rationality, leads to conclude in the absence of compatibility of the CETA ISDS mechanism with EU law, a careful reading of the operative part of the court's ruling might introduce an important nuance. Indeed, the ECJ could perfectly have chosen to rely only on the autonomy principle and an Article 267 to justify its ruling. But it also chose in Achmea to mention Article 344 of the TFEU, which indicates that the member states undertake not to submit a dispute concerning the interpretation or application of the treaties to any method of settlement other than those provided for the Rhine. Many commentators therefore consider that this precision means that the court solution might be limited to intra-EU BITs, meaning those BITs concluded between member states. Time will tell.